25 legal loopholes, centuries of exploitation. One system built to protect the powerful, from corporations dodging murder charges to landlords stealing homes, police seizing cash without conviction to companies owning your DNA. This isn't justice. It's permission slips for the powerful, written in legalese and signed by legislators who knew exactly what they were doing. They wear suits, but they profit from suffering. What you're about to hear are the loopholes they've spent decades pretending don't exist. Because in the American legal system, fairness isn't lost, it's sold. And sometimes the most dangerous thing you can trust is the law. This is 25 disgusting legal loopholes that turned out to be true. Before we dive in, make sure you're subscribed for more deep dives into the systems they don't want you to question. And while you're here, tell me in the comments, where in the world are you watching from, and what time is it right now? Midnight in Miami, 3:00 a.m. in Atlanta. Let's see who else is up discovering the fine print. 1. The double jeopardy loophole. The Fifth Amendment promises it in plain English. No person shall be subject for the same offense to be twice put in jeopardy. Except, of course, when they are, because buried in the case law, preserved through Supreme Court precedent, and deployed whenever prosecutors decide someone deserves a second chance at conviction, there's a loophole wide enough to drive two trials through. It's called the separate sovereigns doctrine, and it means you can be tried for the same crime twice if federal and state prosecutors both want a piece of you. The Constitution says double jeopardy. The courts say separate jurisdictions count as separate offenses. Same evidence, same crime, same defendant, different courthouse. And suddenly, constitutional protection evaporates because sovereignty apparently matters more than the plain text of the amendment. Rodney King's case made this brutally clear. In 1992, 4 Los Angeles police officers were acquitted by a state jury for beating Kings nearly to death. The video was clear. The verdict shocked the nation. And then federal prosecutors stepped in. Same beating. Same defendants. Same evidence presented to a different jury under different statutes. 2 of the officers were convicted in federal court. The Constitution's promise of protection against double jeopardy? Technically intact, practically meaningless. The doctrine traces back to the 19th century, rooted in the idea that states and federal government are separate sovereigns with separate interests. In theory, it prevents one jurisdiction from blocking another's legitimate prosecutorial authority. In practice, it's a tool for prosecutors who didn't like the first jury's answer. It's used selectively, of course. Not every acquittal triggers a second prosecution. Just the ones where public pressure demands it, where the first verdict feels politically unacceptable, where prosecutors coordinate behind closed doors to ensure someone stands trial twice for behavior that occurred once. The coordination is quiet but thorough. Federal prosecutors wait for state outcomes. They prepare backup cases. And when juries deliver the wrong answer, jurisdiction becomes the loophole that makes double jeopardy disappear. The most chilling part isn't the legal reasoning, it's the pretense. Because the amendment doesn't say no person shall be subject for the same offense to be twice put in jeopardy by the same sovereign. It says no person, period. But courts have decided that words mean what they need them to mean when the alternative is letting unpopular defendants walk free. The Constitution protects you from double jeopardy. Unless, conveniently, you're facing prosecutors determined enough to try twice. Mystery preserved, justice optional. But if being tried twice for the same crime feels like a betrayal of constitutional promises, wait until you learn what police can take from you without ever charging you with anything. Because in America, your property is guilty until proven innocent, and proving innocence costs more than most people have. 2. Civil asset forfeiture. In the land of innocent, until proven guilty, your property enjoys no such luxury. In fact, your car can be guilty. Your cash can be guilty. Your house can be guilty. And you? You're just the person who has to prove they aren't. Civil asset forfeiture is a legal process that allows police to seize property they suspect is connected to criminal activity. Notice the word suspect. Not prove, not convict, suspect. The legal standard is so low, it barely qualifies as a standard. Reasonable suspicion that your property was involved in or derived from illegal activity. No arrest required. No charges necessary. No conviction needed. Just an officer's hunch and a seizure form. The property itself becomes the defendant, not you. The property, which is why cases have names like United States Nabi, $124,700 in U.S. currency, or Texas Davershi, 1 gold crucifix. Your car gets charged with a crime, and you have to sue to get it back. The burden of proof reverses instantly. In criminal court, the state must prove guilt beyond reasonable doubt. In civil forfeiture, you must prove your property's innocence by a preponderance of the evidence, which means you need a lawyer, court fees, and time most people don't have. And here's the convenient part. The police department that seized your property often gets to keep the proceeds. Not the general fund, not the state, the department that took it. Departments across the country have supplemented their budgets with forfeitures for decades. Millions seized annually from people never charged with crimes. Traffic stops turn into financial audits. Carrying cash becomes suspicious. The drug war provided the initial justification, but the practice expanded far beyond narcotics. Driving with money to buy a car? Suspicious? Carrying savings because you don't trust banks? Suspicious. The officer decides, the department profits, and the legal system shrugs. In 2014, the Washington Post found that police had seized $2.5 billion in cash from people who were never charged with crimes. The Institute for Justice has documented thousands of cases where people lost life savings, vehicles, and homes without ever seeing a courtroom as a defendant. The Fifth Amendment promises that no person shall be deprived of property without due process of law. Civil asset forfeiture redefines due process to mean sue us if you want it back. The police take your property. The law says it's guilty. And the burden to prove otherwise falls on you, along with legal fees that ensure most people never try. Convenient, profitable, legal. 2 loopholes down, 23 to go. And trust me, they only get worse from here. If you're still with us, hit that subscribe button so you don't miss what else they've buried in the fine print. And drop a comment. Where are you watching from? And what time is it right now? Are you in New York at lunch break? Or somewhere halfway across the world deep into the early morning? Let's see who else is uncovering the system's dirty secrets. 3. The mandatory arbitration clause. When you clicked I agree on that terms of service, you didn't just accept cookies. You signed away your constitutional right to trial by jury. Not that anyone told you. Not that you had a choice. Mandatory arbitration clauses are buried in the fine print of virtually every contract you sign. Credit cards, bank accounts, employment agreements, cell phone contracts, nursing home admissions, even medical services. The language is dense, the placement strategic, and the effect absolute. You waive your right to sue in court, you agree to resolve disputes through private arbitration, and you can't join a class action lawsuit no matter how many other people were harmed the same way. The Supreme Court has blessed this arrangement repeatedly. In AT&T Mobility versus Conception, the court ruled that companies can force customers into individual arbitration and block class action lawsuits, even when the individual harm is too small to justify the cost of arbitration. In Epic Systems versus Lewis, the court extended the logic to employment contracts, allowing companies to require workers to arbitrate disputes individually rather than collectively. Arbitration sounds neutral. Private dispute resolution. Faster than courts. Less expensive. Except the company chooses the arbitration service. The company pays the arbitrator's fees. And arbitrators who rule against companies too often tend not to get selected for future cases. The incentive structure is a marvel of aligned interests, not yours. Theirs. Statistics tell the story the terms of service don't. A study by the Economic Policy Institute found that employees win only 21% of arbitration cases, compared to 36% in federal court. And when they do win, the awards are significantly smaller. The American Association for Justice found that mandatory arbitration clauses are now in contracts covering more than 60 million workers. You signed it when you opened your bank account. You signed it when you bought your phone. You signed it when you took that job. Each signature, another constitutional right, traded for access to services you can't live without. Because the alternative to agreeing? No bank account, no phone, no job. The law calls this freedom of contract. The courts call it efficient dispute resolution. Everyone else calls it leverage. And the most elegant part of the scheme is that most people who sign these clauses never read them. They can't. The average person would need 76 workdays to read all the privacy policies they agree to in a single year. The companies know this. They count on it. The clauses aren't meant to be read. They're meant to be enforceable. You signed it. You're bound by it. And the company that wrote it picked the referee. Of course, giving up your right to sue is convenient for corporations, but if you think arbitration clauses are unfair, wait until you learn what happens when corporations commit actual murder. Because there's a loophole that ensures no executive ever sees a prison cell. 4. Corporate manslaughter shield. When a person kills someone through reckless negligence, it's called manslaughter. When a corporation does it, it's called a regulatory violation. The difference? Prison for the first. A fine for the second. And executives? They were just following company policy. Corporate personhood is a legal fiction that grants companies many rights of individuals. Free speech, religious freedom, due process. But when the criminal law comes calling, corporate personhood becomes a shield rather than a sword. Because while corporations can be charged with crimes, they can't be imprisoned. And the individuals making the decisions that kill people? They're protected by the corporate veil, a legal barrier that separates personal liability from corporate action. The Ford Pinto case set the template. Internal Ford documents showed the company knew the Pinto's fuel tank design was lethal. They calculated that fixing it would cost $11 per car. They estimated the deaths and injuries that would result from not fixing it. They assigned dollar values to human lives. And they decided the lawsuits would cost less than the recall. Between 27 and 180 people burned to death in Pinto crashes, depending on whose estimates you trust. Ford paid fines and settlements. No executive faced criminal charges. The pattern repeated with the opioid crisis. Purdue Pharma executives knew OxyContin was wildly addictive. Internal emails documented their knowledge. They marketed it anyway, targeting doctors in vulnerable communities, downplaying addiction risks, and fueling an epidemic that killed hundreds of thousands of Americans. The company pleaded guilty to federal criminal charges. The Sackler family paid billions in settlements. Not one executive went to prison. Boeing provides the most recent example. Internal messages showed employees knew the 737 MAX had serious safety flaws. This airplane is designed by clowns, who in turn are supervised by monkeys, one employee wrote. 2 crashes killed 346 people. Boeing paid $2.5 billion in fines and settlements. Engineers and executives kept their freedom. The legal doctrine is simple. A corporation acts through its employees, but employees act within the scope of their employment. If the corporation commits a crime, the corporation pays. If an individual commits a crime, the individual pays. But when corporate policy kills people, the gap between individual action and corporate liability becomes a void where accountability disappears. Prosecutors know this. The Justice Department has explicit guidelines for considering the collateral consequences of corporate prosecutions. Will indicting the company hurt innocent employees? Will it damage the economy? The questions are reasonable in isolation, but in practice they create a protection racket. Corporations become too big to prosecute criminally. Executives hide behind corporate decision-making structures. And the criminal justice system that sends individuals to prison for decades accepts fines as penance for mass death. The corporation pays. The executives express regret. And no one goes to prison because the law decided that organizations can commit manslaughter, but only people can be held responsible. Convenient, legal, disgusting. But if corporate immunity from murder feels like a betrayal of basic justice, the next loophole proves that even when companies are caught red-handed committing fraud, the penalty is just another line item in the budget. Because in America, crime doesn't pay, unless you're rich enough to absorb the fine. 5. The too big to prosecute doctrine. In 2008, the world's largest banks nearly destroyed the global economy through systematic fraud. The Justice Department's response? We can't prosecute them. It might hurt the economy. The phrase too big to fail became a rallying cry during the financial crisis. Banks had grown so large and interconnected that their collapse would trigger economic catastrophe. So the government bailed them out. Hundreds of billions in taxpayer money to prevent systemic collapse. The phrase made a certain brutal sense. Sometimes you have to save institutions you'd rather let die. But too big to fail quietly became too big to jail. Because after the bailouts, after the investigations, after years of evidence showing systematic fraud in mortgage lending, securities trading, and financial reporting, no major banking executive faced criminal prosecution. Not one. In 2013, Attorney General Eric Holder testified before Congress and said the quiet part out loud. I am concerned that the size of some of these institutions becomes so large that it does become difficult for us to prosecute them when we are hit with indications that if you do prosecute, if you do bring a criminal charge, it will have a negative impact on the national economy, perhaps even the world economy. The Justice Department had internalized the defense's argument. Prosecuting the bank might cause harm, so don't prosecute. Instead, the government deployed deferred prosecution agreements. The bank admits wrongdoing, pays a fine, promises to behave, and prosecution is deferred indefinitely. If the bank complies with the terms, the charges are eventually dropped. It's a legal timeout for institutions whose fraud caused trillions in losses and millions of foreclosures. HSBC provides perhaps the clearest example. The bank admitted to laundering $881 million for Mexican drug cartels and processing transactions for countries under U.S. sanctions, including terrorist organizations. The Justice Department filed charges, then immediately deferred them. The settlement was $1.9 billion in fines, which sounds substantial until you realize HSBC's revenue that year was $87 billion. No executives charged. No trials. Just a negotiated agreement that a Senate report later concluded was insufficient to deter future misconduct. The individual homeowner who lies on a mortgage application goes to prison. The bank that systematically falsifies thousands of mortgage applications pays a fine covered by shareholders, not executives. The small business that evades taxes faces criminal charges. The corporation that shelters billions offshore negotiates a settlement. Two justice systems, one for institutions large enough to threaten the economy, another for everyone else. And here's the truly elegant part. The fines, however large they appear, rarely exceed the profits from the misconduct. Crime becomes a cost-benefit analysis. If the fraud generates $10 billion and the fine is $2 billion, you've made $8 billion. The law hasn't deterred crime. It's priced it. The banks committed fraud. The government admitted it. And the punishment was a negotiated settlement that ensured no banker would face a jury, because prosecuting them might cause instability. The fraud? That was stable enough. Of course, if you're wondering whether the legal system treats individual citizens with the same consideration, the answer is written in every courtroom where poor defendants are offered plea deals they can't refuse. Because there's another loophole, one that ensures 95% of criminal cases never see a trial. 6. Coerced plea bargains. The Sixth Amendment guarantees you a trial. The reality is that 95% of defendants never get one, not because they're guilty, because they can't afford to risk finding out. Plea bargaining is the engine of the American criminal justice system. Without it, courts would collapse under the weight of trials they're not designed to handle. Prosecutors openly acknowledge this. The system depends on guilty pleas the way an economy depends on credit. And like credit, plea bargaining works through leverage, threat, and the fear of what happens if you don't cooperate. The leverage comes from overcharging. Prosecutors stack charges like plates at a buffet. What could be a single offense becomes 5, 6, 7 charges, each carrying separate penalties. The threat is explicit. Take the plea, serve 5 years. Go to trial, risk 25 if the jury convicts on everything. The choice isn't between guilty and not guilty. It's between certain damage and potential catastrophe. This is called the trial penalty. And courts have acknowledged it exists. In a 2012 dissent, Justice Anthony Kennedy wrote that plea bargaining had become the criminal justice system rather than an alternative to trials. He noted that the trial penalty coerces defendants into giving up their constitutional rights, not because they're guilty, but because the risk is too high. The Supreme Court hasn't fixed this. It simply observed it. The Innocence Project has documented hundreds of cases where innocent people pleaded guilty. The math is cold but clear. You're offered 2 years for a crime you didn't commit versus the risk of 20 years if you lose at trial. You have a public defender managing 200 other cases who has 30 minutes to discuss your options. The evidence is circumstantial, but looks bad. The prosecutor is offering a deal that expires in 48 hours. What do? Human Rights Watch studied federal drug cases and found that defendants who went to trial received sentences 3 times longer than those who pleaded guilty to the same charges. 3 times. Not a 10% premium, not a modest penalty. 3 times. The message is clear. Exercise your Sixth Amendment right to trial, and we will punish you for it. Public defenders, overwhelmed with caseloads that violate every standard for effective representation, encourage pleas because trials aren't realistic. The system doesn't have capacity for trials. Prosecutors know this. They exploit it. And the courtroom hallway becomes the real venue for American justice, where defendants sign away their rights to avoid risks they cannot bear. The prosecutor makes an offer. The defendant does the math. And 95% of the time, the Constitution's promise of a trial dies in a courthouse hallway, buried under the weight of what might happen if you dare to assert your rights. Still, at least those defendants get lawyers. Eventually, because there's a loophole that says you have the right to an attorney, just not necessarily one who's awake, sober, or competent. And the bar for inadequate representation is so low, it barely exists. 7. The ineffective assistance standard. The Supreme Court says you have the right to effective counsel. It also says effective doesn't mean competent, prepared, or even conscious. In fact, your lawyer can sleep through parts of your trial, and it's perfectly legal. The standard comes from Strickland v. Washington, a 1984 Supreme Court case that set the bar for what counts as ineffective assistance of counsel. To overturn a conviction based on bad lawyering, you must prove 2 things. First, your attorney's performance was deficient. Second, there's a reasonable probability the outcome would have been different with competent representation. Both prongs must be met. Miss either, your conviction stands. The first prong sounds reasonable until you see how courts apply it. In a Texas case, the defense attorney slept through portions of the trial. Witnesses testified. Evidence was presented. The lawyer dozed. The defendant was convicted and sentenced to death. On appeal, the court ruled this didn't constitute ineffective assistance because the sleeping occurred during portions of the trial that weren't critical. Calvin Burdine spent 15 years on death row before a federal court finally reversed his conviction. In another case, the attorney was drunk during trial. In another, the attorney called no witnesses and conducted no investigation. In another, the attorney had a sexual relationship with the client while simultaneously representing her. Courts have upheld convictions in each scenario, reasoning that the defendant failed to prove the outcome would have been different. The second prong makes the standard nearly impossible to meet. How do you prove a different lawyer would have achieved a different result? You're asking courts to speculate about a trial that never happened with evidence that was never presented to a jury that never heard it. The standard requires certainty about a hypothetical. The American Bar Association recommends attorneys handle no more than 150 felony cases per year. Public defenders in Louisiana average 400. In Missouri, some carry more than 700. These attorneys aren't ineffective because they're incompetent. They're ineffective because effectiveness isn't possible when you have 20 minutes per client and no time to investigate facts that might save lives. But the Strickland standard doesn't account for systemic failure. It evaluates individual attorney performance, not the structural collapse of indigent defense. So convictions stand. Appeals are denied, and defendants serve decades in prison while courts reason that the representation, however inadequate, doesn't meet the technical definition of ineffective. Your lawyer slept. The court noticed. And your conviction stands because the law decided that unconscious representation still counts as representation. And if inadequate legal representation seems designed to ensure convictions regardless of guilt, that's because it is. But the system doesn't stop at bad lawyers. It also includes evidence that everyone knows is junk science, admitted in courtrooms across America because it's always been admitted. Legacy, not accuracy. 8. Junk science in court. For decades, prosecutors used bite mark analysis to send people to prison for murder. The science was clear. It didn't work. The courts were equally clear. We don't care. Precedent said it was admissible, and precedent doesn't require accuracy. Forensic science sounds authoritative. Expert witnesses in lab coats testifying about scientific certainty. Juries believe science. Prosecutors know this. And for generations, they've introduced forensic evidence that lacks any scientific basis, confident that courts will admit it, because they always have. Bite mark analysis claimed that human teeth leave unique marks, like fingerprints. Forensic dentists testified they could match bite marks on victims to specific defendants. At least 24 people were wrongfully convicted based on bite mark evidence. Then actual scientists tested the methodology. Turns out, bite marks aren't unique. They're not reliable. Multiple studies showed forensic dentists couldn't consistently match bite marks even under controlled conditions. The technique was junk. The convictions stood. Hair microscopy followed the same path. FBI analysts testified in thousands of cases that hair samples microscopically matched defendants. In 2015, the FBI admitted its analysts provided flawed testimony in more than 90% of cases reviewed, 9 out of 10. The National Association of Criminal Defense Lawyers found that 32 defendants had been executed or died in prison based on cases involving flawed hair analysis testimony. The technique was junk. The executions were final. Arson investigation follows patterns rather than chemistry. For decades, arson investigators testified that accelerants, pour patterns, and burn marks indicated intentional fires. Then actual fire scientists examined the methods. Many of the indicators occurred in accidental fires too. The National Academy of Sciences reviewed the field and concluded that much of what courts had accepted as arson science was educated guessing. People sat in prison. Some had been executed. The science was wrong from the beginning. Blood spatter analysis, shaken baby syndrome diagnosis, polygraph tests in some jurisdictions. Each technique presented as science, each adopted by courts, each later shown to be unreliable or outright false. And yet evidence based on these methods remains admissible in many courts because legal precedent values consistency over accuracy. The Daubert standard, established by the Supreme Court in 1993, supposedly requires judges to act as gatekeepers, ensuring expert testimony is based on reliable methodology. In practice, judges defer to law enforcement experts, admit evidence that's been admitted before, and prioritize legal precedent over scientific consensus. If previous courts allowed it, current courts follow suit. The Innocence Project has exonerated more than 375 people through DNA evidence. In approximately 45% of those cases, invalid or improper forensic science contributed to the wrongful conviction. The science was junk. The courts admitted it anyway because the legal system decided that stability matters more than accuracy. The evidence was junk. The scientists knew it. The courts admitted it anyway because legal precedent outweighs scientific fact. Of course, junk science isn't the only unreliable evidence courts embrace. There's also the testimony of witnesses whose memories were shaped by the very detectives investigating the case. Because the law has a special name for that too. And it's still perfectly legal. 9. The witness coaching loophole. Eyewitness testimony is notoriously unreliable, which is why police carefully prepare witnesses before trial, showing them photos, refreshing their memory with case details, and ensuring their testimony aligns with the prosecution's theory. The law calls this proper preparation. Everyone else calls it witness coaching. Memory doesn't work like a recording. It's reconstructive, malleable, easily influenced by suggestion. Every time you recall an event, you're rebuilding the memory, and each reconstruction can incorporate new information. Psychologists have known this for decades. The criminal justice system knows it too. And some of them use it. Suggestive identification procedures are the most blatant example. A witness sees a crime. Police show them a photo array, but the suspect's photo is the only one in color or larger than the others, or the only one in a certain position. Police might say, take your time when the witness looks at filler photos, but fall silent when they reach the suspect's image. These subtle cues guide identification without explicit instruction. Or police conduct a show-up where a single suspect is presented to a witness shortly after a crime. Is this the person? The procedure practically screams, "We think it's him." The witness wanting to help often confirms. Studies show show-ups produce false identifications at alarming rates. Courts still admit them routinely. Then there's the interview process itself. Police interview witnesses multiple times, often providing information about the case between sessions. Details the witness never mentioned initially start appearing in later statements, not because the witness remembered them, but because investigators mentioned them. Memory contamination, the technical term. Witness coaching, the practical one. The Innocence Project has found that mistaken eyewitness identification contributed to more than 69% of the wrongful convictions overturned by DNA evidence. Some witnesses were shown photos of the defendant before being asked to identify them. Some were told other witnesses identified the defendant. Some were given case facts that found their way into identification testimony. The identifications were corrupted. The courts admitted them anyway. Constitutional protections against suggestive identifications are weak and rarely enforced. In Manson v. Brathwaite, the Supreme Court held that even unnecessarily suggestive procedures don't require exclusion if the identification is reliable based on other factors. But those other factors are evaluated after the suggestion has already occurred. The contamination is baked in. And the most elegant part? The defense rarely learns about the contamination. Police reports summarize interviews without detailing every statement, every photo shown, every detail shared. The jury hears confident witness testimony without understanding how that confidence was built through repeated interviews and strategic information sharing. The witness's memory was shaped by police interviews. The jury never learns how, and the conviction stands because the law decided that police helping witnesses remember isn't the same as telling them what to say. 9 loopholes exposed, 16 still waiting. If you're still watching, you're exactly the kind of person who needs to hit that subscribe button, because what's coming next is somehow even worse. Drop a comment below. Where are you watching from, and what time is it? Are you in Chicago between meetings or somewhere across the world where it's already tomorrow? Let's see who else refuses to look away. 10. The qualified immunity shield. When a police officer violates your constitutional rights, you can sue. In theory. In practice, the law requires you to find a previous case where a court ruled that specific violation unconstitutional. Kicked in the head while handcuffed? Find a case. Stolen property during a search? Find a case. Didn't find one? No lawsuit. Qualified immunity is judge-made law. Congress never passed it. Voters never approved it. The Supreme Court invented the doctrine in 1967 and has expanded it repeatedly since. The original reasoning was that police officers shouldn't face personal liability for split-second decisions made in good faith. Reasonable enough in concept. Absurd in application. The doctrine protects officers from civil liability unless they violated a clearly established constitutional right. And clearly established has a specific meaning. You must find a previous case in your jurisdiction where a court held that your specific constitutional violation, under substantially similar circumstances, was unlawful. Not similar circumstances. Substantially similar. The requirement creates an impossible standard. A federal appeals court confronted this in a case where officers stole $225,000 while executing a search warrant. The theft violated the Fourth Amendment, obviously. But the court granted qualified immunity because no previous case had established that officers violating the Fourth Amendment by stealing during a search was unconstitutional. The theft was wrong. The officers kept their immunity. In another case, a prison guard pepper sprayed an inmate who was strapped to a chair, naked and covered in feces. Cruel and unusual punishment, surely. The Eighth Circuit granted immunity because no previous case established that pepper spraying a helpless, naked inmate covered in feces violated constitutional rights. The doctrine creates a catch-22. To overcome qualified immunity, plaintiffs must cite precedent establishing the right. But precedent can't be established without a case overcoming qualified immunity. Rights exist in theory, but have no remedies in practice because the first person to experience a specific violation can't sue, and subsequent victims have no precedent to cite. Officers shoot a suspect who wasn't fleeing and posed no threat. Previous courts said shooting fleeing suspects was unconstitutional, but this suspect wasn't fleeing. Different circumstances. Immunity applies. The logic is a legal Mobius strip. And because plaintiffs lose on qualified immunity grounds, courts often don't reach the constitutional question. They grant immunity without deciding if the conduct violated rights. So no precedent gets established. The cycle continues. The doctrine has become so divorced from its stated purpose that Justice Sonia Sotomayor has repeatedly criticized it in dissents. In one case, she wrote that qualified immunity tells officers that they can shoot first and think later, and it tells the public that palpably unreasonable conduct will go unpunished. The doctrine remains. Statistics are hard to compile because many potential lawsuits are never filed. Attorneys know qualified immunity will block most civil rights claims, so they don't take the cases. But a Reuters investigation found that between 2005 and 2019, federal courts granted qualified immunity in roughly 57% of the excessive force cases that survived summary judgment. The majority of officers sued for constitutional violations escape liability because previous courts hadn't ruled on sufficiently similar facts. The officer violated your rights. The court acknowledged it. And your lawsuit dies anyway because no previous court had ruled that specific violation unconstitutional. Rights without remedies. Protection without enforcement. But if police immunity seems designed to prevent accountability, at least they're public servants bound by some constitutional constraints. Corporations face no such burden. In fact, there's a loophole that lets companies own your genetic code, patent your DNA, and profit from your cells, without your permission, without compensation. 11. The genetic material loophole. When Henrietta Lacks died in 1951, doctors took her cancer cells without consent. Those cells became medical gold, generating billions in profits. Her family got nothing. And the law? It said that was fine. Still does. Henrietta Lacks was a black woman being treated for cervical cancer at Johns Hopkins Hospital. During treatment, doctors took a sample of her cancer cells without asking permission. This was standard practice. Medical research used patient tissue routinely, and consent wasn't required. The cells, labeled Hila for the first two letters of her first and last names, turned out to be extraordinary. Unlike normal human cells that die quickly in lab conditions, HeLa cells thrived and replicated indefinitely. Scientists cultivated them, shared them, sold them. HeLa cells became foundational to medical research. They were used to develop the polio vaccine. They traveled to space. They've been bought and sold billions of times over. Companies built fortunes on them. The Lacks family learned their mother's cells were being used for profit when researchers contacted them in the 1970s for more genetic material. By then, the cells had been commercialized for decades. The legal principle is straightforward. You don't own biological material once it leaves your body. In Moore v. Regents of the University of California, the Supreme Court of California faced a similar question. John Moore's doctor removed his spleen to treat leukemia. The doctor then used cells from Moore's spleen to develop a cell line worth an estimated $3 billion, obtaining a patent without informing Moore or seeking consent. Moore sued. The court ruled he had no property right in his biological material once removed from his body. The logic is that granting patients ownership of excised tissue would hinder medical research. If patients could claim property rights, they could demand royalties, negotiate licenses, complicate distribution of materials essential for scientific progress. Better, the court reasoned, to allow researchers free use of biological material. The benefit to society outweighs individual property claims. Of course, the benefit to society runs through corporate profits. Companies patent genetic sequences, cell lines, and medical innovations derived from patient tissue. They profit from products developed using materials taken from people who never consented and will never be compensated. The research advances. The corporations bank billions. The patients whose bodies generated the material have no claim. After the Human Genome Project, companies began patenting genes themselves. By 2013, about 20% of human genes had been patented. Myriad Genetics held patents on BRCA1 and BRCA2 genes, mutations of which increase breast and ovarian cancer risk. The patents gave Myriad exclusive rights to test for these mutations, allowing them to charge $3,000 per test and block other labs from offering competing tests. In Association for Molecular Pathology versus Myriad Genetics, the Supreme Court eventually ruled that naturally occurring genes can't be patented, but synthetically created DNA sequences can be. The ruling was narrow. Much of the genetic material loophole remains intact. Your cells generate data. Companies harvest it, patent applications derived from it, and profit from discoveries made possible by your biological material. You have no right to compensation, no claim to profits, no say in how your genetic material is used once it's out of your body. Medical research benefits undeniably, but the law decided that your body is yours until it's useful to someone else. Then it's theirs. And if losing ownership of your own DNA seems like a violation of bodily autonomy, the next loophole takes it further. Because there's a legal doctrine that says companies can fire you for needing pregnancy accommodations, and the courts will call it attendance policy, not discrimination. 12. The pregnancy discrimination workaround. Federal law prohibits pregnancy discrimination. It's clear, explicit, and thoroughly enforced. Unless your employer fires you for missing work due to pregnancy complications, then it's just attendance, not discrimination. Attendance. The Pregnancy Discrimination Act of 1978 amended Title VII of the Civil Rights Act to explicitly prohibit discrimination based on pregnancy. The language is unambiguous. Women affected by pregnancy shall be treated the same as other employees similar in their ability or inability to work. The law requires equal treatment. The reality is anything but. The loophole operates through neutral policies. An employer can't say, "We're firing you because you're pregnant." That's obviously illegal. But they can say, "We're firing you for attendance violations." And if those attendance violations stem from morning sickness, prenatal appointments, or pregnancy complications, well, the policy doesn't discriminate based on pregnancy. It discriminates based on attendance. The distinction is paper thin. Courts often accept it anyway. The Supreme Court narrowed protections further in Young v. UPS. Peggy Young was a delivery driver who became pregnant. Her doctor restricted her from lifting more than 20 pounds. UPS provided light-duty accommodations for workers injured on the job, those with disabilities under the ADA, and those who lost DOT certifications. They refused to accommodate Young's pregnancy-related restriction. She was forced to take unpaid leave and lost her benefits. The court eventually ruled in her favor, but the standard it established was weak. Employers must accommodate pregnant workers only if they accommodate other workers similar in their ability to work. The comparison game allows employers to distinguish pregnant workers from other temporarily disabled workers through carefully written policies. Women have been fired for experiencing pregnancy complications that required time off, for attending prenatal appointments, for needing bathroom breaks more frequently, for requesting to sit occasionally in jobs that require standing. The employer doesn't cite pregnancy as the reason. They cite the policy violation. And when the worker sues for pregnancy discrimination, she must prove the employer's stated reason was pretextual. That pregnancy was the real motivation. Hard to prove when the policy is facially neutral. The Equal Employment Opportunity Commission receives thousands of pregnancy discrimination charges annually. Between 2011 and 2015, approximately 31,000 charges were filed. Some resulted in findings of discrimination. Many didn't. And those numbers represent only the cases where workers filed formal charges. Most pregnant women who lose their jobs never file because they can't afford attorneys, can't wait years for resolution, and can't risk being labeled difficult employees. The Pregnant Workers Fairness Act, passed in 2022, attempts to close some gaps by requiring employers to provide reasonable accommodations for pregnancy, childbirth, and related conditions. Whether it works depends on enforcement, and enforcement depends on workers knowing their rights and having resources to assert them. History suggests optimism should be cautious. The law prohibits pregnancy discrimination. The employer cites attendance. The woman loses her job and her lawsuit. Legal. Disgusting. Still happening. Of course, if you're wondering whether the legal system provides any protection for workers, you're asking the wrong question. Because there's a loophole that lets employers classify you as an independent contractor, strip away all labor protections, and the burden to prove otherwise falls entirely on you. And that's if you can afford a lawyer. 13. Misclassification of workers. You work 60 hours a week. You have a manager. You use company equipment. You follow company rules. But according to your employer, you're an independent contractor, which means no minimum wage, no overtime, no benefits, and no recourse. The distinction between employee and independent contractor determines everything. Employees get minimum wage, overtime pay, unemployment insurance, workers' compensation, anti-discrimination protections, and the right to unionize. Independent contractors get none of this. They're business owners selling services. Their relationship with the company is contractual, not employment-based. In theory, contractors control how they work. In practice, companies control everything except the label. The legal tests for determining employment status are deliberately ambiguous. The IRS uses one test. The Department of Labor uses another. Various states have their own standards. Some focus on the degree of control the company exercises. Some examine economic dependence. Some apply multi-factor balancing tests where no single factor is determinative. The ambiguity is a feature. It allows companies to classify workers as contractors regardless of the actual relationship. Uber and Lyft built business models on this loophole. Drivers use the company's apps, accept rides through their systems, follow their rules about customer service, and face deactivation if they don't maintain ratings thresholds. But they're independent contractors, which means they're not entitled to minimum wage, even when they net less than minimum wage after expenses. No overtime, even when working 60-hour weeks. No unemployment insurance when demand drops. No workers' compensation when they're injured. The companies externalized all employment costs onto workers while maintaining operational control. California passed AB 5 in 2019, requiring companies to prove workers are genuinely independent using a strict ABC test. The gig companies responded by spending $200 million on a ballot initiative, Proposition 22, exempting themselves from the law. It passed. Voters were told it would protect driver flexibility. What it actually protected was the company's ability to avoid employment obligations while dictating when, where, and how drivers work. The Economic Policy Institute estimates that between 10 and 30% of employers misclassify workers, affecting somewhere between 10 and 20 million workers. The variation in estimates reflects how difficult it is to identify misclassification. Companies don't advertise it, workers often don't know they're misclassified, and enforcement agencies lack resources to investigate more than a fraction of potential violations. When workers challenge misclassification, they bear the burden of proof. They must file claims with labor agencies or sue in court, both of which require time, money, and expertise most misclassified workers lack. Companies settle cases quietly with confidentiality agreements, ensuring other workers never learn about successful challenges. The misclassification continues, profitable and largely invisible. You work for them. You answer to them. But you're not their employee. The law requires certain tests to determine classification. The company ignores them. And unless you can afford to fight in court, you're exactly what they say you are. Still, at least misclassified workers have the option of finding different employment, unlike prison inmates who can be forced to work for pennies per hour in what the law carefully avoids calling slavery. Because there's an exception in the 13th Amendment, one sentence, 16 words, and it's still being used today. 14, the slavery exception. The 13th Amendment ended slavery in America. Read it carefully. Neither slavery nor involuntary servitude except as a punishment for crime. That word except is doing a lot of work. Specifically, about $2 billion worth of unpaid or barely paid prison labor every year. The language wasn't accidental. When the 13th Amendment was ratified in 1865, Southern states immediately began using the exception to criminalize black life. Vagrancy laws, loitering statutes, and selective enforcement filled prisons with formerly enslaved people who were then leased to private companies and forced to work. Convict leasing generated enormous profits and continued well into the 20th century. The chain gang, another form of prison labor, became iconic images of Southern justice. The exception permitted it all. Modern prison labor is more sanitized, but functionally similar. Inmates in state and federal prisons work in kitchen, laundry, and maintenance jobs that keep prisons operating. They manufacture products sold commercially. They staff call centers. They fight wildfires in California. They're paid between 14 cents and 63 cents per hour on average, though some states pay nothing at all. Texas and Georgia don't pay prison workers at all for most jobs, and refusing to work isn't really an option. Prisons punish inmates who refuse work assignments with solitary confinement, loss of privileges, denial of parole consideration, or other disciplinary measures. The work isn't voluntary. It's compelled. The 13th Amendment permits involuntary servitude as punishment for crime. Courts have repeatedly held that prison work programs don't violate constitutional protections because the exception explicitly allows it. The products of prison labor are everywhere. Inmates manufacture military uniforms, furniture for government offices, license plates, and countless other goods. Private companies contract with prisons for labor. McDonald's, Walmart, and Victoria's Secret have all used prison labor at various points. The workers have no choice about employment, no ability to negotiate wages, no right to refuse assignments. The companies benefit from costs far below minimum wage. The prisoners are paid pennies because the Constitution says that's allowed. This isn't just about the labor itself. It's about how the criminal justice system feeds the need for workers. When prison populations increase, so does available labor. When states privatize prisons, those private companies have financial incentives to keep facilities full. And when the 13th Amendment accepts punishment from prohibitions on involuntary servitude, it creates a legal framework where incarceration becomes a labor pool. Several states have recently passed or proposed constitutional amendments to remove the exception language. Colorado did it in 2018, Nebraska in 2020, Alabama, Tennessee, and Vermont in 2022. The changes are symbolic more than practical. They don't immediately end prison work programs or raise wages, but they acknowledge what the federal Constitution still won't, that the exception to the ban on slavery permits slavery. The amendment abolished slavery, except when it didn't. The exception swallowed the rule, and prisoners work for pennies because the Constitution carved out permission, one word at a time. But if forced prison labor seems like an artifact of outdated constitutional language, the next loophole is distinctly modern. Because there's a legal doctrine that says if you've been arrested, police can take your DNA and add it to a permanent database, even if you're never convicted, even if charges are dropped. Your genetic profile is theirs forever. 15. The DNA database loophole. When you're arrested, police take your fingerprints. They also take your DNA. And while fingerprints might be returned if you're acquitted, your genetic code stays in the system. Forever. Searchable. Permanent. Yours, but also theirs. The practice started as a tool for solving violent crimes. DNA databases would contain profiles of convicted criminals, allowing investigators to match DNA from crime scenes to known offenders. Reasonable enough. But like most law enforcement tools, the program expanded. States began collecting DNA upon arrest, not just conviction. The rationale was efficiency, catching criminals earlier, solving cold cases, preventing future crimes. The justification creep was predictable and thorough. In Maryland v. King, the Supreme Court ruled that DNA collection upon arrest doesn't violate the Fourth Amendment. Alonzo King was arrested for assault and had his DNA taken. His profile matched DNA from an unsolved rape case. He was convicted of that rape and challenged the DNA collection as an unreasonable search. The court held that DNA collection is a legitimate booking procedure, similar to fingerprinting and photographing. Justice Kennedy's majority opinion compared DNA swabs to routine identification procedures and found the intrusion minimal compared to the state's interest in identifying arrestees. The dissent, written by Justice Scalia, was scathing. He noted that DNA collection had nothing to do with identification. King's identity wasn't in question. The DNA was used solely to investigate unsolved crimes. The majority had blessed a suspicionless search designed to trawl databases for possible crimes rather than identify the person in custody. But the dissent lost. DNA collection upon arrest became constitutional. What the court didn't address, and what states have exploited, is retention. In many states, DNA profiles remain in databases even after charges are dismissed or defendants are acquitted. The policies vary. Some states require formal requests for expungement. Some have automatic removal procedures that aren't actually automatic. Some states retain DNA indefinitely, regardless of case outcome. The Combined DNA Index System, CODIS, maintained by the FBI, contains over 14 million offender profiles. These aren't just convicted criminals. Arrestees are included. And as states collect DNA more broadly, the database grows. Law enforcement can search it for investigations unrelated to the original arrest. Your DNA, collected when you were arrested for a crime you didn't commit, can implicate you in investigations years later. And it's not just direct matches. Familial DNA searches use partial matches to identify relatives of people in the database. If your brother's DNA is in CODIS, police can find you through genetic similarities. Your genetic privacy is compromised by your relative's arrest. The networks expand exponentially. You were arrested, maybe convicted, maybe not. Either way, your DNA is filed, indexed, searchable. The Fourth Amendment protects against unreasonable searches. The Supreme Court decided this was reasonable. And if permanent genetic surveillance feels invasive, at least it applies only after arrest. The next loophole requires no arrest at all, because police can stop and frisk you on the street based on nothing more than reasonable suspicion. A term so vague, it means whatever officers say it means. 16. Terry stops abuse. The Fourth Amendment requires a warrant based on probable cause. Terry v. Ohio carved out an exception for brief investigative stops based on reasonable suspicion. And reasonable has turned out to mean whatever police want it to mean. Terry v. Ohio, decided in 1968, created the legal framework for stop and frisk. An officer may briefly detain someone if they have reasonable suspicion that criminal activity is afoot. The stop must be temporary and limited in scope. Officers may also conduct a pat-down search for weapons if they reasonably believe the person is armed and dangerous. The court balanced Fourth Amendment protections against officer safety and effective law enforcement. The balance tipped toward police discretion. Reasonable suspicion is a lower standard than probable cause. Officers don't need evidence sufficient for arrest. They need articulable facts suggesting criminal activity. The standard is deliberately vague, granting officers discretion to make judgment calls on the street. And like most discretionary powers, it's been expanded and abused. New York's Stop and Frisk program under Mayor Bloomberg provides the clearest example of Terry's degeneration. At its peak in 2011, NYPD conducted nearly 700,000 stops. The vast majority occurred in minority neighborhoods. The vast majority found no evidence of criminal activity. In 88% of stops, the person was innocent. Officers stopped young Black and Hispanic men repeatedly for behaviors like walking in high-crime areas, wearing certain clothing, or exhibiting furtive movements, a phrase so broad it could mean almost anything. In Floyd v. City of New York, a federal court found the NYPD's stop and frisk practices violated the Fourth Amendment and constituted racial profiling under the 14th Amendment. The court ordered reforms, though implementation has been contentious and incomplete. But the decision didn't strike down Terry stops themselves. It just required that they be based on actual reasonable suspicion, rather than quotas and racial profiling. The problem is that reasonable suspicion remains hopelessly subjective. An officer's training and experience supposedly provide the basis for articulable suspicion, but in practice, post hoc justifications paper over pretextual stops. A person matches the description of a suspect, even when the description is generic. They're in a high-crime area, even when that describes entire neighborhoods. They made furtive movements, even when that just means avoiding eye contact or changing direction when police approach. And once stopped, the conversation becomes consensual. Officers ask questions, request to search. Most people don't know they can refuse. Most people don't feel free to leave. The stop bleeds into something more invasive, and courts defer to officers' testimony that the person consented or that additional reasonable suspicion developed during the encounter. If officers find evidence during a Terry stop, it's admissible. The exclusionary rule, which prohibits using evidence obtained through unconstitutional searches, doesn't apply if the stop was reasonable. And since reasonableness is determined by the officer's subjective belief based on their experience, it's nearly impossible to prove a stop was unreasonable unless the officer admits to having no basis. The Constitution requires probable cause. Terry created an exception for reasonable suspicion. And reasonable has been defined down to include being in the wrong neighborhood, wearing the wrong clothes, or looking in the wrong direction. But if vague standards for street stops seem designed to permit maximum police discretion, they're nothing compared to the loophole that lets prosecutors hide evidence of innocence. Because there's a constitutional requirement to disclose exculpatory evidence. And there's also a culture of ignoring it without meaningful consequences. 17. Brady violations without punishment. Brady versus Maryland is clear. Prosecutors must turn over evidence favorable to the defense. It's a constitutional requirement. It's also routinely ignored. And when violations are discovered, the punishment is so rare, it might as well not exist. The Supreme Court decided Brady v. Maryland in 1963, holding that due process requires prosecutors to disclose evidence favorable to the accused. The obligation applies whether or not the defense requests it. Exculpatory evidence includes anything that might prove innocence, impeach prosecution witnesses, or reduce the severity of the offense. The rule seems straightforward. In practice, it's a mess. First, prosecutors decide what qualifies as material. Brady requires disclosure only of evidence that's material, meaning there's a reasonable probability it would affect the outcome. But prosecutors make materiality determinations before trial, when they don't yet know how the case will unfold. If they decide evidence isn't material, they don't disclose it. The defense never learns it exists. Second, the remedy for Brady violations requires proving prejudice. Even if prosecutors withheld exculpatory evidence, the conviction stands unless the defendant can show a reasonable probability the outcome would have been different. Same problem as ineffective assistance of counsel. You're asking courts to speculate about what might have happened in a different trial. Third, and most damning prosecutors who violate Brady face almost no professional consequences. The National Registry of Exonerations has identified prosecutorial misconduct, including Brady violations, in hundreds of wrongful conviction cases. Prosecutors who withheld evidence, suppressed witness statements, or hid deals with informants faced no professional discipline, no disbarment, no suspension. In most cases, not even public reprimand. Michael Morton spent 25 years in prison for murdering his wife. He was innocent. The prosecutor withheld evidence pointing to another suspect, including a witness statement that contradicted the prosecution's timeline. Morton was eventually exonerated through DNA evidence. The prosecutor, who withheld the evidence, he became a judge. He was eventually sanctioned, but only after decades of concealment, and only because Morton's appellate attorneys fought relentlessly for accountability. The sanction was a brief suspension and a small fine. One of the few prosecutors ever disciplined for a Brady violation. In another case, California prosecutors withheld evidence that their star witness had received favorable treatment in exchange for testimony. In another, prosecutors suppressed forensic evidence that undermined their theory. In another, they hid deals with jailhouse informants. Convictions were overturned in some cases. Many stood. The prosecutors faced nothing. The incentive structure encourages violations. Prosecutors want convictions. They evaluate evidence through that lens. If disclosing evidence might weaken their case, materiality determinations tilt toward non-disclosure. And if violations are discovered years later, the prosecutor has usually moved on. Maybe they're in private practice. Maybe they're a judge. Maybe they've retired. Accountability is theoretical. The National Association of Criminal Defense Lawyers and the Innocence Project have called for systematic reforms. Open file discovery, where prosecutors disclose everything rather than deciding what's material. Independent review boards for prosecutorial misconduct. Professional discipline with teeth. None of these reforms have been implemented broadly. The system protects prosecutors more zealously than it protects defendants' rights. The rule says, disclose. Prosecutors decide what counts. Violations are discovered years later. And the prosecutors, they're still in office, still prosecuting cases, still deciding what the defense deserves to see. And if prosecutorial misconduct seems bad, at least it might eventually be discovered. The next loophole is built into the system itself, because there's a statute of limitations on most crimes, unless you're poor. Then the government can pursue you forever for minor debts, garnish your wages, and compound interest until you owe 10 times the original amount. 18. The debt collection time loop. Murder has a statute of limitations in some states. Credit card debt, eternal. Your $500 medical bill from 2003? In the right state, it's now $5,000, and a debt collector just garnished your wages. Statutes of limitations exist to protect defendants. Memories fade. Evidence deteriorates. Witnesses disappear. After enough time, defending against accusations becomes impossible. So the law draws lines? 6 years for most felonies, shorter for misdemeanors. For some serious crimes, no limit at all. The logic is that severity determines how long the state can wait before pursuing charges. But that logic doesn't apply to civil debt. In many states, there's no statute of limitations on collecting debts, or the limitations are so long they might as well be eternal. 15 years in some states, 20 in others, and every time a debtor makes a partial payment, the clock resets. $1 payment on a 14-year-old debt. Congratulations, you just reset the statute. Even better from a creditor's perspective, old debts can be sold to debt, buyers for pennies on the dollar. The original creditor writes off the debt, takes a tax deduction, and sells the account to a collection agency. That agency pays maybe 3 cents per dollar of face value. Then they pursue the full amount, plus interest, fees, and whatever else they can tack on. The debt buyer files suit, often in courts, far from where the debtor lives. The debtor doesn't receive proper notice or doesn't understand the summons. They don't appear. The court enters a default judgment. Now the debt buyer has a court order allowing them to garnish wages, levy bank accounts, and place liens on property. All for a debt the debtor might not even remember owing. And those default judgments? They're epidemic. Studies show that roughly 90% of debt collection lawsuits result in default judgments, not because the debts are all valid, because debtors don't show up. They don't know they need to. They don't understand how to defend themselves. They don't have attorneys. The system depends on defaults. Zombie debts, the industry term, are old debts that resurface after being dormant for years or decades. Maybe the debt passed through multiple collection agencies. Maybe the debtor moved states and lost track. Maybe they genuinely forgot. The collection agency files suit in a state with favorable statutes, serves process in ways that ensure the debtor never actually receives notice, and obtains judgments by default. The Federal Trade Commission has documented systematic abuses in debt collection, collectors threatening arrest for debts they can't legally collect, suing for debts already paid, using fabricated or incorrect information. The penalties are minimal compared to the profits. And even when caught, agencies pay fines that are dwarfed by revenue from collections. And here's the really elegant part. Once a judgment is entered, it can last decades longer than the original statute of limitations. In some states, judgments are good for 20 years and can be renewed indefinitely. Your $300 debt from 2005 becomes a $3,000 judgment in 2010 that follows you until 2030, potentially renewed until 2050. The debt never dies. It compounds, multiplies, and haunts. The debt is ancient. The interest has compounded. And your paycheck is garnished because you missed a court date for a hearing you didn't know about. Time barred for violent felonies. Eternal for $200 you borrowed in 2005. Still, at least debt collection eventually ends when the money's extracted. The next loophole is permanent. Because once you're convicted of a felony, even after you've served your time, states can strip your voting rights forever. The sentence ends. The punishment doesn't. 19. Felony disenfranchisement. You served your time. You're out of prison. You've completed parole. You're rebuilding your life. But in several states, you still can't vote. Not because you're incarcerated, because you once were. Permanent punishment for a completed sentence. 11 states. Disenfranchise some or all people with felony convictions even after they've completed their sentences. The restrictions vary. Some automatically restore rights after a waiting period. Some require applications and fees. Some leave restoration to the discretion of governors or clemency boards. And some make restoration so difficult it rarely happens. Florida provides perhaps the clearest example. Until 2018, the state permanently disenfranchised felons unless the governor personally restored their rights. More than 1.6 million Floridians couldn't vote because of past convictions. In 2018, voters approved Amendment 4, automatically restoring voting rights to most people with felony convictions after they complete their sentences. It was a massive voting rights victory, until the legislature intervened. In 2019, Florida's legislature passed SB 7066, requiring people with felony convictions to pay all fines, fees, and restitution before their voting rights would be restored. The requirements effectively turned rights restoration into a poll tax. Many people have no idea what they owe. Court records are incomplete. Fees accumulate through interest. And people without resources to hire attorneys can't navigate the system to determine eligibility. A federal court initially blocked the law as unconstitutional. An appeals court reversed. The fight continues. Meanwhile, hundreds of thousands of Floridians remain disenfranchised because they can't afford to buy back their voting rights. The historical origins of these laws are explicit. After the 15th Amendment prohibited denying the vote based on race, Southern states immediately enacted laws disenfranchising people with felony convictions. The laws were paired with black codes criminalizing activities like vagrancy, loitering, and unemployment. Offenses enforced almost exclusively against black people. One Alabama delegate to the 1901 Constitutional Convention openly stated the goal was to establish white supremacy in this state. The disenfranchisement laws worked exactly as intended. Combined with selective enforcement and discriminatory sentencing, they stripped voting rights from huge numbers of black citizens while maintaining plausible constitutional legitimacy. The 14th Amendment permits states to abridge voting rights based on participation in rebellion or other crime. States exploited that permission ruthlessly. Modern disenfranchisement laws maintain this impact. Research by the Sentencing Project found that 2.3 million Black citizens are disenfranchised, representing 6.2% of the Black voting age population, compared to 1.7% of the non-Black population. In some states, more than 20% of Black adults are disenfranchised. The racial disparities aren't accidents. They're features of systems designed over a century ago to suppress Black political power, and the laws accomplish this without explicitly mentioning race. Intent to discriminate must be proven. Historical intent isn't enough if the modern law is facially neutral. The Supreme Court has allowed these laws to stand despite their origins and ongoing discriminatory effects. The sentence is complete. The debt to society paid. But the ballot box remains closed because the law decided some rights can be revoked forever. But if permanent disenfranchisement seems like a relic of Jim Crow, that's because it is. And it's not alone. Because there's another loophole that traces directly back to segregation-era laws, one that lets schools expel students without due process hearings. Zero tolerance meets zero constitutional protection. 20. School discipline without due process. When an adult faces criminal charges, they get a hearing. When a student faces expulsion that could derail their entire future, they get a meeting with an administrator who's already made the decision. Due process in schools? Optional. Subjective. Racially skewed. The Supreme Court established in Goss v. Lopez that students facing suspension have some due process rights. They must receive notice of the charges and have an opportunity to explain their side. But the required process is minimal. No right to a lawyer. No right to confront witnesses. No formal hearing. Just a conversation with school administrators who've already investigated and formed conclusions. Zero tolerance policies make even this minimal process meaningless. Under zero tolerance, certain offenses trigger automatic punishments, regardless of circumstances. Bringing a weapon? Expulsion? Fighting? Suspension? Drug possession? Expulsion. The policies remove administrative discretion, which sounds fair until you examine how they're applied. A 6-year-old brings a plastic knife to school to cut his lunch. Weapon. Suspension. A teenager gives a friend an Advil. Drug distribution. Expulsion. A student brings a pocket knife in his car's toolbox, forgotten from a weekend camping trip. Weapon on school property. Expelled. Zero tolerance means zero judgment, and the data shows these policies disproportionately harm students of color. The Government Accountability Office found that Black students, particularly boys, are disciplined more frequently and more severely than white students for similar behaviors. Black students represent 15.5% of public school enrollment, but 39% of suspensions. For subjective offenses like defiance or disrespect, the disparities widen further. The school-to-prison pipeline starts here. Students suspended or expelled are significantly more likely to drop out, to be arrested, to become involved with the criminal justice system. Suspension becomes a pipeline entry point. And while all students suspended face these risks, the disproportionate suspension rates for Black students mean the pipeline channels predominantly Black children toward incarceration. Due process protections that apply in criminal court don't transfer to schools. Students have no right to discovery, no ability to compel witnesses, no meaningful appeal. School boards review administrative decisions with extreme deference. Courts review school discipline with even more deference, rarely overturning decisions absent truly egregious circumstances. And unlike adults, students can't choose to leave. Compulsory education laws require attendance. When a student is expelled from one school, finding another becomes difficult or impossible. Alternative schools, where they exist, often provide inferior education. The expelled student falls further behind academically, increasing the likelihood of dropping out. Parents can hire attorneys to fight expulsions. Families with resources sometimes win. But most families don't have resources. They can't afford lawyers. They don't know how to navigate administrative hearings. They don't understand their limited rights. The student is expelled and the trajectory is set. The offense is subjective. The hearing is perfunctory. The punishment is life-altering. And the Constitution's due process requirements? Schools get a pass. And if educational institutions seem insulated from constitutional requirements, they are not alone. Because there's a loophole that lets nursing homes force residents into arbitration agreements when they're most vulnerable, stripping away the right to sue for neglect, abuse, or wrongful death. Sign here or find care elsewhere. 21. Nursing home arbitration trap. Your elderly parent needs care. The nursing home has a bed. They also have a contract. Signing away the right to sue or find somewhere else. Your parent's too sick to wait? You sign. And when neglect kills them, you discover you signed away your day in court. Nursing homes require arbitration agreements as a condition of admission. The clauses are buried in admission paperwork, presented during crisis moments when families are desperate for care. An elderly parent has been hospitalized. They can't return home. They need round-the-clock care. The nursing home has an opening. Here's the 40-page contract. Sign on page 37. Most families sign without reading. Even those who read don't negotiate. There's nowhere else to go. The arbitration clauses prevent lawsuits for abuse, neglect, wrongful death, and virtually any other claim against the facility. Instead, disputes go to private arbitration. The nursing home industry chooses the arbitration service. The arbitrators are paid by the industry. And the results are confidential, meaning families can't learn about other cases or patterns of abuse. A 2009 study found that 91% of nursing homes included mandatory arbitration clauses in their admission agreements. The number has likely increased. After the Obama administration banned mandatory arbitration in nursing home contracts for facilities receiving Medicare and Medicaid funding, the Trump administration reversed the rule. Arbitration clauses are back and enforceable. The consequences are exactly what you'd expect. A California nursing home repeatedly ignored a resident's bed sores until they became infected, leading to sepsis and death. The family discovered the arbitration clause only when trying to sue for wrongful death. Their case went to arbitration. The arbitrator, selected from the nursing home industry's preferred list, ruled for the facility. The decision is confidential, so other families can't learn from it. Arbitration outcomes favor nursing homes. Industry-funded arbitrators don't want to be removed from the pool. They rule accordingly. Awards, when families do win, are typically lower than jury verdicts, and the proceedings are private, preventing public scrutiny of care quality or systemic problems. Consumer advocates have fought these clauses for years. Some states have banned them. Federal efforts have been proposed and blocked repeatedly. The nursing home industry lobbies aggressively to maintain arbitration requirements, arguing they reduce costs and frivolous lawsuits. Translation: they reduce accountability. And the timing of these contracts makes them particularly coercive. Families sign during medical crises. The elderly parent is often cognitively impaired, unable to understand or consent. The family member signing has no leverage. The facility knows this. They know families will sign anything to get care. The contracts exploit vulnerability with legal precision. The contract was signed under duress. The care was fatal. And the lawsuit dies in arbitration because your moment of desperation was their moment of leverage. But if forcing arbitration on vulnerable elderly people seems unconscionable, it's at least transparent compared to the next loophole. Because there's a legal doctrine that says when government officials destroy evidence, deliberately or accidentally, there's almost no remedy. And the burden to prove destruction was intentional? That falls on you. Using evidence that no longer exists. 22. The evidence destruction loophole. You file a lawsuit against the police. You request video evidence. The department reports the footage was accidentally deleted, or the hard drive failed, or the camera malfunctioned. Prove it was intentional. Without the footage, good luck. Body cameras were supposed to increase police accountability. Officers wear cameras that record interactions with the public. When misconduct occurs, the footage provides objective evidence. Except when the footage conveniently disappears. The excuses vary. Storage system failures, technical glitches, officers forgetting to activate cameras, videos being overwritten before litigation begins. Each explanation sounds plausible in isolation. The pattern reveals intentional destruction, masked as technical incompetence. A study by the Leadership Conference on Civil and Human Rights found that police departments routinely fail to retain body camera footage, particularly in cases involving use of force. Retention policies are inadequate. Officers have discretion to delete footage. Oversight is minimal. And when footage disappears in cases where misconduct is alleged, departments claim it's just bad luck. Courts impose sanctions for spoliation, the legal term for destruction of evidence. But sanctions require proof that the destruction was intentional and that the missing evidence would have been favorable. It's a catch-22. To prove intentional destruction, you need evidence. The evidence was destroyed. And to prove the destroyed evidence was favorable, you need to show what it contained. But it doesn't exist anymore. The legal standard is willfulness. Negligent destruction usually isn't sanctioned, so departments claim accidents. Officers claim they forgot. IT departments claim system errors. Without proof of intent, courts don't impose meaningful consequences. And even when sanctions are imposed, they are usually limited. Adverse inference instructions tell juries they can assume the destroyed evidence would have supported the plaintiff's claims. But juries are told they can assume, not that they must. The destroyed evidence speaks louder in its absence than any inference instruction. And here's the elegant part. Departments have policies requiring video retention, but officers control activation and storage. If an officer doesn't activate their camera, there's no video to destroy. If they claim they forgot, it's their word against the absence of evidence. The policy provides cover without mandating compliance. In high-profile cases, footage disappears with startling regularity. A suspect dies in custody. The camera malfunctioned. An officer uses excessive force. The video was automatically deleted according to retention schedules. A pattern of misconduct. Technical failures across multiple devices. Private parties who destroy evidence face serious sanctions, adverse inferences, fines, even dismissal of their claims. But government actors? The standard is higher. Courts defer to government explanations. Technical failures are accepted at face value, and the destroyed evidence leaves only speculation. The evidence existed. Then it didn't. The timing was convenient, the explanation technical, and your case collapses because you can't prove intentional destruction using footage that no longer exists. Still, at least evidence destruction requires some effort, even if that effort is pressing delete. The next loophole is even simpler, because prosecutors have absolute immunity for virtually anything they do in their prosecutorial role. Withhold evidence? Immune. Lie to the court? Immune. Fabricate evidence? Probably still immune. The legal standard protecting prosecutors is broader than the one protecting anyone else in the justice system. 23. Absolute prosecutorial immunity. When police officers violate rights, qualified immunity might protect them. When prosecutors do it, absolute immunity shields them. The standard is even higher. The protection nearly impenetrable. And the remedy for wrongful conviction caused by prosecutorial misconduct? Good luck. Absolute immunity is exactly what it sounds like. Prosecutors cannot be sued for actions taken in their prosecutorial role, even when those actions are malicious, in bad faith, or result in wrongful convictions. The doctrine comes from Imbler versus Pachtman, where the Supreme Court held that prosecutors need immunity to function effectively without fear of harassment through litigation. The reasoning was that prosecutors must make quick decisions, exercise discretion, and advocate zealously. If they could be sued for every decision, they'd be paralyzed by potential liability. The court drew a line. Prosecutors have absolute immunity for advocacy, like presenting evidence at trial or making charging decisions. They have only qualified immunity for investigative functions, like directing police investigations. The line seems clear until you try to apply it. Courts have interpreted prosecutorial functions broadly. Withholding exculpatory evidence, prosecutorial function. Immune, presenting perjured testimony. Prosecutorial function. Immune, making false statements to the court. Depends on context, but usually immune. The protection extends so far that even intentional misconduct in pursuing convictions rarely opens prosecutors to liability. In Connick versus Thompson, John Thompson spent 14 years on death row, came within weeks of execution, before discovering prosecutors had withheld blood evidence that would have proven his innocence. The prosecutors knew about the evidence. They hid it. Thompson was exonerated and sued. The Supreme Court ruled against him. The prosecutors had absolute immunity for their trial conduct, and the district attorney's office couldn't be held liable for failure to train because this was an isolated incident, not a pattern. Thompson received nothing for 14 years of wrongful imprisonment. In another case, prosecutors manufactured evidence against a suspect, coerced witnesses, and suppressed exculpatory evidence. The defendant was convicted and served years in prison before being exonerated. He sued. The prosecutors claimed absolute immunity. Courts agreed. Their misconduct occurred while performing prosecutorial functions. Immune. The narrow exception for investigative acts rarely applies. Courts define prosecutorial functions broadly, giving immunity in almost all circumstances. And even when prosecutors cross into investigative territory, they're often protected by qualified immunity instead. 2 layers of protection ensure accountability is theoretical. Statistics on prosecutorial discipline tell the story, immunity doesn't. The National Registry of Exonerations identified prosecutorial misconduct in hundreds of cases. Academic studies estimate thousands more cases involve misconduct that's never discovered or that doesn't result in exoneration. Yet prosecutors are almost never disciplined. Bar associations rarely sanction prosecutors for misconduct. State disciplinary boards almost never revoke licenses. The few prosecutors who face consequences are outliers. Michael Morton's case resulted in one of the rare sanctions. The prosecutor who withheld evidence was eventually found in contempt, served a brief jail sentence, and lost his law license for a period. The sanctions came only because Morton's appellate attorneys fought for years, and because the evidence of misconduct was overwhelming and undeniable. Most cases aren't so clear. Most prosecutors face nothing. Absolute immunity ensures that the incentives favor misconduct. Win convictions through any means. If you're caught, you're protected. If the conviction is overturned, the defendant goes free, but you face no consequences. The system is designed to maximize convictions, not accuracy. The prosecutor withheld evidence. You spent decades in prison, you're exonerated. And you can't sue, because absolute immunity means absolute. Prosecutors decide what justice means. The law ensures they never face consequences for getting it wrong, or for getting it wrong on purpose. And if prosecutorial immunity seems designed to prevent accountability, that's because it is. But at least prosecutors operate within the criminal justice system. The next loophole allows civil seizure without any criminal proceeding at all. Because the government can take your home through civil forfeiture, claim it was used to facilitate a crime, and you have to sue to get it back. Sound familiar? That's because we started with cash. Now, We end with houses. 24. Home seizure without criminal conviction. Civil asset forfeiture started with cash and cars, but the law doesn't discriminate. Your home can be seized the same way. Someone commits a crime on your property? The property is guilty. You're just the person who used to live there. We started this list with civil asset forfeiture of cash and vehicles, but the doctrine extends to real property. Homes, land, buildings. If police believe your property was used to facilitate drug crimes or other offenses, they can seize it. No criminal conviction required. No proof that you, the owner, knew about or participated in any criminal activity. A tenant deals drugs from an apartment? The landlord's property can be seized even if the landlord had no knowledge and took reasonable steps to prevent illegal activity. An adult child sells marijuana from their childhood bedroom while visiting parents? The parent's home is subject to forfeiture. Someone plants marijuana on your vacant land? Your land can be seized. The legal standard is preponderance of the evidence. More likely than not that the property was used in furtherance of crime. Lower than criminal convictions beyond reasonable doubt. Lower than even probable cause for arrest. Just more likely than not, determined by a judge in a civil proceeding. The innocent owner defense exists in theory. If you can prove you didn't know about and couldn't have reasonably known about the illegal activity, you might keep your property, but the burden is yours. You must prove innocence, and reasonable knowledge is interpreted broadly. Courts often find that owners should have known, could have prevented, or failed to take adequate steps to stop illegal activity on their property. In Philadelphia, a couple's home was seized because their son sold $40 worth of drugs from the porch. The parents had no knowledge. The son was arrested and charged. The city moved to seize the house. The parents fought the forfeiture for years, ultimately reaching a settlement. But they had to hire attorneys, pay legal fees, and endure years of uncertainty about whether they'd lose their home because of their adult son's actions. The Institute for Justice documented case after case of home forfeitures. Multi-generational family homes seized because a relative committed a crime. Rental properties seized because tenants engaged in illegal activity. Businesses closed because an employee used the premises for drug transactions. In each case, the government kept the property, sold it, and kept the proceeds. And just like with cash seizures, law enforcement agencies benefit directly. Seized homes are sold. Proceeds go to the seizing agency's budget. The financial incentive corrupts enforcement priorities. Agencies target high-value properties where forfeiture is profitable, not where crime is most serious. The Eighth Amendment's excessive fines clause theoretically limits forfeitures. In Timms v. Indiana, the Supreme Court held that the clause applies to civil asset forfeitures and that forfeitures grossly disproportionate to the gravity of the offense violate the Constitution. But the standard for excessiveness is unclear, and lower courts have applied it inconsistently. Most forfeitures survive Eighth Amendment challenges. The cash was just the beginning. They moved to cars, then homes. Your property is guilty. You're just the owner. And getting it back requires a lawsuit. You probably can't afford to prove innocence you shouldn't have to prove. Still, at least home seizures involve government action, however unjust. The final loophole is more elegant, because there's a legal doctrine that says corporations are people for constitutional purposes. Free speech, religious freedom, political donations, but not for criminal prosecution purposes. When convenience requires personhood, they have it. When accountability demands it, suddenly they're just legal fictions. 25 loopholes. One pattern. The law protects power. 25 selective corporate personhood. Citizens United declared corporations are people for First Amendment purposes. They can spend unlimited money on political speech. They can exercise religious freedom. They can assert rights. But when prosecutors come calling, suddenly they're just legal entities, people when convenient, fictions when accountable. Corporate personhood has existed in American law for over a century. The concept originated as a legal convenience. Corporations can enter contracts, own property, sue and be sued. This allows businesses to function efficiently without requiring every shareholder to personally sign every agreement. It's a useful fiction, but the fiction expanded. In Citizens United vs. FEC, the Supreme Court held that corporations have First Amendment free speech rights, allowing them to spend unlimited money on political campaigns. In Burwell v. Hobby Lobby, the court held that closely held corporations can exercise religious freedom under the Religious Freedom Restoration Act, exempting them from Affordable Care Act requirements to provide contraception coverage. Corporations gained constitutional rights historically reserved for human beings. The expansion is strategic. When corporations want to spend money influencing elections, they're people with speech rights. When corporations want to refuse employee benefits based on owner religious beliefs, they're people with religious freedom. But when corporations commit crimes and face criminal liability, suddenly they're separate from the humans who control them. This selective personhood creates a liability shield. Corporations can be charged with crimes, but they can't be imprisoned. The penalty is always financial. Fines, restitution, sometimes monitored compliance programs. But executives who made the criminal decisions, they are shielded by the corporate structure. The corporation acted, not the individual. We saw this pattern in the corporate manslaughter shield. Executives hide behind corporate decision-making. Prosecutors struggle to prove individual mens rea when decisions are made through committees and communications are deliberately structured to obscure individual responsibility. The corporation is the defendant. The executives remain free. The contradiction is stark. Corporations claim personhood to assert rights, but disclaim personhood to avoid responsibilities. When it's advantageous, they're people. When it's constraining, they're just legal entities that can't be treated like people. The law accommodates both positions, granting rights without equivalent accountability. And the consequences extend beyond criminal liability. Corporations have used personhood to challenge regulations, assert privileges, and claim protections. But when those same protections would impose duties, like personal liability for corporate actions, personhood becomes a metaphor, not a mandate. The principle bends to serve corporate interests. This selective application reveals what the legal system actually prioritizes. Corporations need rights to participate in politics, to exercise power, to shape society. But they can't have responsibilities that might genuinely constrain their actions or expose their decision-makers to consequences. The asymmetry isn't accidental. It's the system working as designed. 25 loopholes. One theme. The law bends toward those who write it, enforces against those who can't fight it, and calls the gap justice. Corporate persons with rights. Human. Persons without remedies. A system that works exactly as designed, not broken. Built this way. These aren't bugs in the legal system. They're features, carefully drafted, strategically deployed, and defended by people who profit from their existence. 25 legal loopholes that turned out to be true. Because in America, the fine print isn't just there to protect the powerful. It's there to ensure the powerful never need protection at all. They wrote the law. They just forgot to write your name into it.